All right.
Oh, he's like a tight ship here, unlike in private years.
Well, welcome everyone, and good afternoon, and welcome to Osler's Pension and Benefits Seminar, and welcome to those who are participating by webinar. My name is Tony Deaver, and I will be your MC today. First, some administrative points. For those that are here in person, if you're looking for the washrooms, out the doors and to the left. Today's seminar will be comprised of two panels, each running for about an hour. In total, there will be no intermission, and there will also be cocktails and hors d'oeuvres after the seminar has concluded. As far as questions, we will have a brief Q&A period at the end of each panel. If you have a question, we'll provide you with a microphone so that the webinar participants can hear the question. Also, you'll be able to chat with the speakers and ask them questions at the reception at the end of the presentation. For those who are participating by the webinar, questions can be asked using the right-hand side control panel, and the webinar questions that are not addressed in the seminar, we will be responding later. As far as education credits, for those who need them, you'll be getting a certificate of attendance for your CPD credits, which will be circulated by email at the end of the week, together with the materials from today's presentation. And lastly, as far as feedback, whether you are participating by the webinar or are here in person, your views are very important to us, and so we would appreciate it if you would provide feedback. For those participating by webinar, there'll be an online survey at the end of the session that you can complete. And for those who are attending in person, we've got feedback cards on the table, and we'd appreciate it if you could fill them in and leave them on the table at the end. Now, with those logistical details behind us, I thought I would take a moment to reflect on the recent changes that have affected the pension and benefits industry. We've seen changes in the approach to funding DB plans. After years of temporary solvency funding relief, we saw Quebec introduce some more permanent solvency funding reforms in 2016. And from May the 1st of this year, we've got Ontario's new DB solvency funding rules that came into effect. Other provinces, Nova Scotia and Manitoba, are in the middle of a consultation process that is looking at more permanent solvency funding solutions. We've also seen significant change at the regulatory level. We're in the process of transitioning to a new pension regulator from FSCO to the Financial Services Regulatory Authority, or FSRA. And effective January 1 of this year, there's a new tool for the Ontario Pension Regulator to use, and that's the Administrative Monetary Penalties, or AMPs, which leaves a lot of options for punning. We also have, with the Ontario 2018 budget, it included some amendments to the Pension Benefits Act to provide a framework for a disclosable events regime, which is similar to the regime that's in the US. And under this regime, corporations are required to report on certain yet to be determined events, but there's been a hint at it in the budget with talking about reporting on significant asset stripping or the issuance of extraordinary dividends, which may have some reference to a recent insolvency. The Ontario 2018 budget also included amendments to the PBA that would allow the superintendent to have the power to approve funding agreements in the context of CCAA or bankruptcy and insolvency proceedings. We've also seen some pension plans take the initiative in seeking to expand DB coverage. We've got the CAP plan and OP Trust of each offering a DB benefit that is less than and at a lower cost than the regular DB benefit provided under their plans. The CAP plan is offering DB Plus, which is targeted to, I think, almost everyone, broader public sector, not-for-profit sector, private sector within Ontario or outside of Ontario. We've got OP Trust is offering OP Trust Select, which is more narrowly targeted to Ontario workplaces. In the broader public sector, charitable and not-for-profit groups targeting those that don't have a workplace DB plan but might have a defined contribution plan or a group RSP or even no retirement savings. And these are all from their respective websites. So, we are also seeing pension plans sort of move to consolidation. I think particularly the CAP plan has been involved with the merging of single employer plans into the CAP plan. We've seen the ROM plan, the Youth Service Bureau of Ottawa pension plan has merged into the CAP plan already, and I understand they're in the process of engaging in discussions with Torstar, and there's a regulation that is set to come into force on July 1 that names 8 pension plans that are sponsored by Torstar or its affiliates that could be the subject of a merger. We've also seen changes addressing pension de-risking. A lot of provinces have responded to the industry requests for a statutory discharge where an ongoing plan purchases a buyout annuity. The latest province to respond to this request is Ontario, and their rules come into force on July 1. We've had the benefits industry hasn't been immune to change. From the impact of legalization of marijuana to the Ontario government extending free prescription drug coverage to people under 25, to the recent case coming out of the Human Rights Tribunal that questions the validity of provisions of the Human Rights Code that, in effect, permit group benefit plans to limit coverage for employees who are over age 65. So I thought I'd encapsulate this in this pictorial, which what this really depicts is that the pension and benefits industry has been experiencing a sea of change. Yes. There we go. Okay, and the topics in today's seminar is going to cover some of these areas of change. And the first panel here is going to help us navigate through one of these recent changes, the new Ontario DB funding rules. For webinar participants, bios for the speakers have been sent to you, and for people attending in person, there are bios in the handout materials which have a lot of other useful information, including some recent publications that this department has issued. Turning to the panel, the speakers on the panel are, on my immediate right, Paul Littner, Chair of Osler's Pension and Benefits Department, a recognized leader in the industry and a trusted advisor to several public sector pension plans. To Paul's immediate right is my partner, Julien Roger, whose pension and benefits practice is based out of our Montreal office. We're also fortunate to have 2 actuaries from ECLA who will provide their perspective on the new Ontario funding rules. Next to Julien is Jill Wagman, who is the managing principal at ECLA and a leading actuary in the pension industry. And beside her is Daniela Vega, who is also an actuary at ECLA. And with that, I'm going to turn it over to Paul.
Thanks, Tony. So this afternoon, our panel of lawyers and actuaries will kick off by attempting to both decipher and summarize for you the recent amendments to the Pension Benefits Act Ontario, or PBA for short, and its related regulations that we've collectively called Ontario's new DB funding rules. I'm going to start off by providing an overview of what I'll call the rather complex array of changes to the PBA and its regulations that brought into effect these new DB funding rules, with some commentary from my colleague Julienne on how the Ontario rules might be contrasted and compared to Quebec's recent funding reforms, which were put in place in 2016. After Julienne, Jill is going to illustrate how these new DB funding rules might apply in practice to DB plans and their sponsors with a few illustrative hypothetical examples. And then finally, Daniela, who's batting cleanup today, will round out our discussion by giving you some insights on what changes to pension investment strategies and or de-risking behaviors that these new DB funding rules might drive. So before I get into the new DB funding rules, let me just do a little bit of level setting by refreshing everyone's understanding of the old or pre-reform DB funding rules. So basically, pension plans, or all single employer DB pension plans, have to be funded on both a going concern and a solvency basis to a 100% target. So funding target 100%, both solvency and going concern. There are some exceptions to these general rules, largely based on categories or types of plans. For example, jointly sponsored pension plans, or JSPPs for short, multi-employer pension plans, or MEPs for short, are not required to fund on a solvency basis. Certain of them are exempt from solvency funding, and they're going concern only. And then certain public sector plans are exempted by regulations from solvency funding requirements. As to the time frame over which you're required to pay down deficits, going concern deficits have to be amortized over no less than a 15-year period. Solvency deficits have to be amortized over 5 years or less. Just for clarification, there are no express requirements, or were, in the PBA for margins, funding reserves, or provisions for adverse deviations, or PFAS for short. Of these old rules, as I call them, the most challenging for plan sponsors proved to be the solvency funding requirements. And over the past decade or so, they've been said by many sponsors to be the main cause of contribution volatility to their DB plans. And as a result of that, and sponsor lobbying and industry lobbying, the government then proceeded to repeatedly grant so-called temporary solvency relief measures over a period of several years. They did this multiple times. But that was then, and this is now. So after May 1, 2018, we got a new set of rules. But before we get there, just to remind everyone, this has been a bit of a process. It actually started back at the end of 2015 when the government announced its intention to review DB funding rules. There were then a series of proposals and consultations with the industry. We then finally got amendments to the PBA itself at the end of 2017, which provided general or amendments to definitions. And then the final details in the regulations that were passed are released in April of 2018. And those are contained in Ontario Regulation 250/18, which has all the detailed rules of the new funding requirements. All of these requirements came into force or into effect on May 1, 2018. So they are currently in effect right now. Although many of the provisions, as we'll explore a bit in a minute, will come into effect throughout 2018 and even into 2019, depending on your plan. Okay, just so I don't keep you in suspense any longer, here's a quick overview of the key changes to the PBA and regulations affecting DB plan funding, those that came into effect on May 1, 2018. Now, before I jump into the details, I'll tell you that when the Government of Ontario first started considering changes to DB funding, they stated that the purpose of their review was to develop a balanced set of solvency funding reforms that would focus on plan sustainability, affordability, and benefit security, and take into account the interests of various pension stakeholders. And this balance that they were striving to achieve, I think, shows up in the final rules, which can best be described as various changes which collectively achieve a compromise of the competing objectives of, on the one hand, plan sustainability and affordability, and on the other hand, benefit security. So at a high level, the main changes are reduced or lower solvency funding targets with a higher or more stringent going concern funding requirement. Let's just call that going concern plus. And the plus is basically shortening the amortization period for funding from 15 to 10 years, and the addition of a new requirement to add a funding reserve against future adverse deviations in case the plan's experience is worse than assumed for funding purposes. And other trade-offs that are part of this collective balancing for the reduced solvency funding targets are increases to PBGF coverage and assessments, as well as new restrictions on both benefit improvements and contribution holidays. And then finally, there are additional requirements applicable to administrators about reviewing your plan text and your statement of investment policies and procedures to make sure that they conform to the new requirements of the regulations, as well as additional enhanced disclosure obligations in member and former member annual and biannual statements. So now let's look in a bit more detail at the new DB funding rules. First off, when do they come into effect? Well, as I mentioned, the changes to the PBA and the regulations are already in force, already in effect. They are law. But they will apply to different pension plans at different times, depending on the date of the next actuarial evaluation, and some of the reforms come into effect at a later date. So for instance, the new rules will apply only to actuarial evaluations dated after December 31, 2017. So in effect, there will be a transition period where some plans will continue to fund under the old rules until such time as a new valuation report is due and is filed that complies with the new rules. Valuation reports, due on or after September 2018 have to comply with the new rules, although there is an extension granted for filing times to November 30th if your valuation date is between December 31, 2017 and March 1, 2018. The new PBGF changes are currently in effect. They will apply to all plans with a wind-up date on or after May 19, 2017, so it's got a look-back component to it. But the new assessments for the expanded PBGF coverage don't come into effect until January 1, 2019. So in summary, while May 1, 2018 is a key date in terms of it becoming legally effective, much of it will be implemented and phased in throughout 2018 and beyond. Who do the new rules apply to? Well, first off, they apply only to Ontario-registered pension plans. That is the funding component. If you have a plan registered federally or in another province, these funding rules don't apply to your plan, other than, of course, the PBGF rules that apply to Ontario members wherever the plan is registered. These rules apply to all single-employer pension plans unless they have a specific exemption in the PBA regulations. They will also apply to JSPPs, but not the JSPPs that are listed in Section 1.3.1 of the PBA regulations, which is mainly the existing large, broader public sector jointly sponsored pension plans that we're all familiar with. So they're not subject to these rules. The rules also appear to be designed to apply to MEPs, although not specified Ontario multi-employer plans immediately, unless they convert to target benefit MEPs. But because those rules are in transition, the application to MEPs isn't entirely clear at this point. So focusing now on what are the key changes. First of all, solvency funding. As I mentioned, the solvency funding target for DB plans has been reduced, not eliminated, reduced. It's now reduced from 100% to 85%. So if your plan's solvency ratio is greater than 85%, no solvency special payments are required. If it's less than 85%, special payments are required, but only in such amount as to bring the deficiency back to a 85% solvency funded ratio. Letters of credit can continue to be used in solvency funding, but only to a maximum of 15% of the plan's solvency liabilities, and any existing LCs can be reduced to take you down to that 85% threshold. According to FSCO's estimates, approximately 15% of plans registered in Ontario will still be required to make solvency payments under these revised new standards. Moving on to the new going concern funding rules, what I call the going concern plus basis. It's basically same as it was before, your going concern valuation with the addition of this funding reserve known as a provision for adverse deviation, or PFAD. The PFAD applies to both the normal cost and total going concern unfunded liabilities, but you are permitted to exclude future indexation benefits in determining the PFAD. The amortization periods for going concern deficits under going forward, they're reduced to 10 years for any going concern unfunded liability that arises in evaluation report if it's filed after the May 1, 2018 deadline, but remains at 15 years for going concern unfunded liabilities established in prior evaluation reports. The amount of this funding reserve, or PFAD, I'm not going to go into too much detail. I think Jill is going to explain to us how this works in practice a little bit later, but it's determined based on a formula by reference that's variable by reference to three factors. The first is whether or not your DB plan is open or closed to new members. The second is based on the plan's target asset allocation as between fixed income and non-fixed income assets as set out in the plan's Statement of Investment Policies and Procedures. And the third factor is the excess of the plan's discount rate over a benchmark discount rate, which is established in accordance with the prescribed requirements in the regulations. As you might expect, a number of additional transitional rules were also put into place to soften the impact on sponsors from moving from these old funding rules into the new regime. These include permitting the deferral of up to 1 year for all new solvency and going concern special payments. So your first payment isn't due until 1 year following the valuation date. Transitional rules allowing any solvency excess to be, in a new report, to be used to reduce monthly payment amounts or amortization periods for previous solvency special payment schedules, as well as a provision saying that if your total contributions under the new report are in excess of what you would have paid under the old rules, you can phase those additional obligations in over a 3-year period. And just to say, temporary solvency funding relief options, most recently those that were introduced in 2016, will no longer be applicable once you're under the new regime. Another component of this trade-off that I talked about, or the balancing act for greater benefit security, is PPGF coverage. So Ontario has enacted, previously announced and then enacted changes to the PBA, which will apply to all Ontario members of plans that are wound up after May 19, 2017. The main enhancement is to increase the maximum level of benefits covered by the PPGF from $1,000 a month to $1,500 a month. Why the retroactive look back to May 19, 2017? I think the government was pretty open about the fact that they were trying to make sure that it covered Sears, which is a prominent pension plan insolvency. Of course, no enhanced PPGF coverage or benefits comes without some cost, and somebody has to pay for all this increased coverage. PPGF is not in a surplus position after all. So this will have to come in the form of additional PPGF assessments, which will come into effect commencing January 1, 2019. I think Jill will explain to us a little bit more about how this gets calculated, and I won't speculate on how they might apply to any individual plan, but I would say if I was a betting man, I wouldn't bet that they're going down. So I should say also that the new rules specify that if your plan is in a surplus and has something called an available actuarial surplus, you can use that. It's clear to pay for PPGF premiums as long as you comply with restrictions on taking contribution holidays. So I'm just giving the highlights of the main thrust of the DB funding rules, but there are some important complementary changes to the PBA and regulations that are also aimed at better promoting the benefit security part of this balancing act. First are new limits on benefit improvements. So under the new rules, plans have to be funded at least to 80% on both a solvency and a going concern basis in order for a benefit enhancement to be valid, unless your amendment was filed prior to May 1, 2018. If your plan is not 80% funded, sponsors can still make the benefit improvement if a lump sum contribution is made to fully fund the cost of the improvement. Any cost of the improvement in excess of that 80% threshold can be amortized over an 8-year period. Likewise, contribution holidays. The new rules in the PBA further restrict the circumstances in which contribution holidays can be taken by employers and members by introducing a new concept of available actuarial surplus and saying that contribution holidays can only be taken from available actuarial surplus. A plan has available actuarial surplus if no special payments are required, the plan is fully funded on a going concern basis, including the funding reserve for PFAD, and the plan's transfer ratio is not less than 105%. And for public sector plans, it'll be the solvency ratio as opposed to the transfer ratio. Another noteworthy change under the PBA that goes hand in hand with the funding rules are new requirements, as I mentioned earlier, for enhanced disclosure in your member and former member statements will include a description of the planned transfer ratio both at the beginning and a projected transfer ratio at the end of the evaluation period. And just to remind people, the government had previously announced that they would also be enacting requirements to prepare and file a funding policy and governance policy for a plan. Those have not yet been acted, and with the election, who knows where those will go, where they will go. So that's just a wait and see. And I would be remiss as a pension lawyer if I didn't point out to you that there are specific requirements now relating to plan documents in the new funding rules. Specifically, your plan has to be amended within 12 months of the first evaluation report to specify the employer's obligation to fund the PFAD, among other things. And your Statement of Investment Policies and Procedures, your SIP, will have to identify a target asset allocation for each asset class specified in the PBA regulations, which is used in support of the new PFAD requirements, if it doesn't already do that. So as administrators, this will mean that you should be reviewing these two documents in particular to determine whether they meet the PBA requirements or whether or not you have a compliance issue. So I'm now going to hand it over to Julianne just to give you a bit of perspective by contrasting Ontario's approach with that adopted in Quebec.
So at a very high level, we can say that Ontario and Quebec are generally going in the same direction, and that they are both moving away from solvency funding and imposing more stringent requirements on a going concern basis as a trade-off. So essentially, they're both adopting the going concern plus model that Paul was just talking about. Of course, you can never expect Ontario and Quebec to agree too much on anything. So obviously, there are obviously material differences between the two reforms, and I'll just highlight a few of them for you very briefly. The main difference is really that Quebec eliminated solvency funding entirely for all plans, whereas Ontario only reduced the solvency target to 85%. This difference may be driven in part by the fact that there is no equivalent to the PBGF in Quebec, so there isn't really a financial risk for the province if DB plans are significantly underfunded on a solvency basis. Also, it's important to know that Quebec's unions were consulted as part of this reform, and they were completely on board with the concept of eliminating solvency funding requirements entirely. So it was definitely less risky politically and financially for the Quebec government to go further than maybe it was for the Ontario government. Another difference is how the provision for adverse deviations, or PFAD, is calculated. So both provinces have come up with their own method and formula to determine that provision. In Quebec, the level of the provision is based on a prescribed scale, and I won't get into a detailed explanation about how this scale works. You can, if you're interested in the differences, I'll be happy to discuss about it with you afterwards. Suffice to say that Quebec plans are required to have a reserve of about 13 to 16% right now on average, and I think this is slightly higher than what we will see for Ontario plans. And I'm hearing that the regulators and the Quebec government are considering tweaking the scale to increase the provision a bit. So I think overall we'll have generally a slightly larger reserve for Quebec plans than for Ontario plans. But despite the need to fund this provision, employer contributions have generally gone down, and there hasn't been really a deterioration of the funded status overall. So I think we can say that the transition went pretty well, and the various stakeholders are still, relatively satisfied with the reform. I think the only thing we're really hearing about these days is whether we should tweak the formula for the provision a little bit, but overall it's been going pretty well. On the investment side, I would say that plan administrators have generally stayed the course. So I can't say we've seen major shifts in asset allocation just to shave off a few percentage points off the provision. It's been, obviously all plan administrators are reviewing their SIP, bearing in mind these the new conditions, but it hasn't been, we haven't seen drastic short-term changes to investment policy. And one last difference I wanted to point out is that Quebec plan members who elect to transfer the commuted value of their benefits out of a plan can be paid in proportion to the degree of solvency of the plan, and without having a right to a residual benefit. So if your plan is 80% funded, you can pay out 80% of the benefit of the commuted value, and the member doesn't have a right to the extra 20%, and the employer doesn't have to fund the extra 20%. So this is a measure that has been very well received by plan sponsors in Quebec, and it's a measure that didn't make its way into the Ontario reform. So that's another key difference between the two reforms.
Thanks, Julian. Okay, I'll just wrap up here. I mean, I've given you a whirlwind, high-level overview of the new DB funding rules, and I think what I'm hoping you'll take from that, other than the big picture of what's on the table, is that these rules will affect plans and their sponsors quite differently, depending on, among other things, whether the plan's open or closed, what its asset mix is, and its funded status. So what I'd like to do now is turn it over to Jill to walk us through some examples and show us how the new rules might work in practice.
Thanks, Paul. So what Paul and Julianne referred to in respect to the changes in the going concern funding is going concern plus, we've been referring to it as a strengthening of the going concern. So essentially making the going concern funding more robust in light of the fact that the solvency funding is more relaxed. And so there's two key components to that. One is shortening of the amortization period to 10 years. And then there's the introduction of a PFAD in the rules. Now, PFAD is something that's new to the Ontario Pension Benefits Act, but it's not a new concept for actuaries. And in fact, it's not a new concept for plan sponsors. It's just that under the new rules, it's an explicit reserve, whereas under the previous rules, it was a discussion that was held between the actuary and the plan sponsor. And actually, under our actuarial standards, it was up to the plan sponsor to decide how much conservatism they wanted to build into their discount rate. So the actuary didn't actually have to put in a PFAD. We usually recommended that the sponsor do that for conservatism, but it was really at their discretion. So now it's been taken out of sort of the actuarial and plan sponsors' hands and made mandatory. Just a little bit more about the PFAD. It's similar to the Quebec formula, but different. I think the concepts are the same and the spirit of it is the same, but of course they came at it a bit of a different way. So in Ontario, there's really three components. The first one's very straightforward. It's a fixed amount. So if your plan is open, it's 4%, and if your plan is closed, meaning no new entrants can join the plan, then it's 5%. And that just reflects the fact that the regulator believes there's a little bit more risk associated with a closed plan. There's two variable amounts. So the first variable amount is based on the plan's exposure or asset mix, exposure to non-fixed income assets or equities are considered riskier than fixed income assets, and also whether the plan is open or closed. So they kind of hit you twice on that one. And then the last amount is a variable amount that is based on the going concern discount rate relative to the benchmark discount rate. And Danielle is going to get into the details of that one a bit more in a moment. But just in terms of those first two components, so the fixed component plus the variable component, you could see that based on this table, for a plan that has no fixed income assets, 100% non-fixed income assets, you could see that For a closed plan, the PFAD can be up to 28% for these first two pieces, and then you add on the third component, whereas for an open plan, it's 16%. So the range is quite big, and you can see it gets quite significant the more equities you have or non-fixed income assets you have in your plan. So the idea was for me to walk through two case studies. One thing to note, the rules vary considerably depending on the type of plan, the asset mix, but also because of this benchmark discount rate component, it also does depend on how conservative the plan was beforehand. So I'll show you two examples. The first example is a plan that had approximately 30% fixed income. So you would argue that's a bit more of an aggressive investment mix relative to the average 60-40 that we're all familiar with. And this plan was an open plan. So the fixed amount was 4%, and then the variable amount based on 30% fixed income allocation was 5.5%. And then that third component, the variable amount based on the benchmark discount rate, added another 2.7% to arrive at a total PFAD of 12.2. So in this example, I'm going to show you the funding requirements under the old rules and the new rules. So you can see on a going concern basis that this plan is very well funded. It's got assets of $34 million, liabilities of just under $26 million. So surplus of 8, and most importantly, a funded ratio of 132% on a going concern basis. The target funding ratio, given that their PFAD is 12.2%, is 112.2%. So that's really what they have to fund to on a going concern basis. On a solvency basis, under the old rules, they would be considered underfunded. You can see that the solvency assets are less than the liabilities by about $3.8 million, leading them to have a funded ratio just under 90%. But under the new rules, they do pass that 85% threshold, and so their target funded ratio, I would say, sort of is 105% on a solvency basis, just in the sense of below that they could not take a contribution holiday. So under the old rules, in the first year, now any new special payments at any one valuation can be deferred for a year. So that's why you'll see year 1 and then years 2 and 3 here. But under the old rules, this plan had a current service cost of about $53,000 per month. So it's a fairly small plan. It's actually a not-for-profit organization, so this is really welcome news for them. And they had solvency special payments, previously established solvency special payments of $18,000 per month, leading to a total contribution of $71,000. In years 2 and 3, because at the last valuation a new deficiency emerged, their solvency special payments jumped from $18,000 to $71,000 a month. So that's a very significant increase for this small not-for-profit organization. Under the new rules, because of the exemption of solvency funding, because they're above 85%, all of those special payments are eliminated, and their current service cost does go up a bit, and that's because there's a 12.2% increase in their current service cost, which is representative of the PFAD. So a pretty good news story for this small not-for-profit organization. Next case study I'll look at is a larger pension plan, but a very well-funded pension plan, so one would think that it's still good news. This pension plan is closed, so their fixed amount of their PFAD is 5%. Their variable amount, because they're a closed plan, they were invested more conservatively, so they actually had 50% allocation to fixed income. And that led to a variable amount of 4.6%. And then the benchmark discount rate variable amount actually was 0 for this plan. And I should point out that that benchmark discount rate amount, it does change from month to month depending on the valuation date. And it bops around, I'm noticing, about 20 basis points from month to month. So it could have an impact one month and not the next month. So this plan had a PFAD, despite the fact that it's closed, so considered more risky under the regulations, because of its 50% allocation to fixed income, it's got a PFAD of only 9.6%. So what I wanted to illustrate in this example is the impact of the new rules on the ability for an organization to take a contribution holiday. So under the current rules, or the previous rules, you essentially had to be fully funded to take a contribution holiday. So funded on a going concern basis at 100%, and the same was true for solvency. But under the new rules, you actually have to be fully funded on a going concern basis at 100% plus your PFAD. So in this organization's case, it would be 109.6%. And you also have to have a minimum solvency funded ratio of 105%. So what that meant for this organization, you could see that on a going concern basis, they were 147% funded, so a very, very well-funded plan. And even on a solvency basis, they were 114% funded. So under the old rules, that would allow them to take contribution holiday for, I think, about 7 years. But under the new rules, because they really only have 21.1 million of surplus, out of that 33, they have to keep some left in the plan on a solvency basis to maintain that 105% solvency ratio. So under the new rules, whereas they could have extended their contribution holiday well into the next valuation period, they would actually have to start contributing after about 2 2/3 years. And the last thing I wanted to highlight, Paul mentioned the PBGF changes, and there were a couple elements to those changes in terms of how the premiums are calculated. So the first part is that they eliminated the basic $5 assessment per member and the minimum assessment of $250. They increased the risk-based assessment by 50%, representing the 50% increase in the benefits. And the risk-based assessment was calculated related to how much of a solvency deficiency the plan had. But I've got this underlined here. They added an assessment of 0.015% of a plan's PBGF liabilities. So it doesn't matter if the plan is 114% funded on a solvency basis, and that were it to wind up, they would never make a claim. They're still going to have to pay 0.015% of their liabilities to the fund. So what that meant, and there's an increase in the maximum assessment from $300 to $600 per member. I just wanted to illustrate what that meant. So for the ABC is actually the second plan I showed you, which is a very well-funded plan. The very well-funded plan in the past would have only had to pay into the PBGF about $5,675, and that's just reflective of the fact that it was so well-funded. But under the new rules, that has increased to $37,847. And then in terms of the other plan, the small plan that was not as well-funded, you can see that their previous PBGF assessment was about $22,000, and that has also increased. But their previous PBGF assessment was that high because of their funded status. So just some interesting outcomes of the rules that may or may not have been intentional. So with that, I'll turn it over to Daniela.
Okay. Thanks, Jill. So as mentioned, my focus today is on the implication of the new funding rules on pension investments. So I want to just take a minute to discuss the PFAS kind of under an investment lens and then shift to reviewing a case study. So this is a repeat of one of Jill's slides. The table here shows the combined PFAD for that fixed component determined based on whether the plan is open or closed, as well as the PFAD that's indicated based on the non-fixed income assets. So just wanted to touch on sort of the definition of non-fixed income versus fixed income assets. And so in this context, non-fixed income assets include equity, so things like Canadian and foreign stocks, but also half of any allocations to things that are not strictly bonds or cash. So that would include asset classes like real estate, mortgages, infrastructure. And so in my discussions, I'll collectively refer to those as alternatives. Another important point is that the fixed income assets are required to have a minimum credit rating to be considered as such under the new regulations. So Paul had mentioned potential amendments to SIP. So these classifications of fixed income versus non-fixed income assets, they do relate to the target allocations as they're outlined in the investment policy. And the policies, may need to be amended to also provide for the specific classifications of the various investments of the plan as defined under the new regulation. So Jill referenced that third component of the PFAD, which is related to the benchmark discount rate, and I thought I'd give a little bit of detail on how that's determined. So the benchmark discount rate is made up of 4 components. So first, it's based on the yield on long-term government bonds at the valuation date. So this is what Jill was referring to, in that it's quite dynamic and it changes based on the valuation date and the yields that are in effect at that time. So in addition to that yield on Government of Canada bonds, there's a 1.5% premium for the fixed income assets that you're holding, another 5% premium for the non-fixed income assets that you hold, and then another fixed component of 0.5%. So that in total makes up your benchmark discount rate, and the PFAD that you have to hold is really the excess of the going concern discount rate over that benchmark rate and multiplied by the duration of the plan. Sounds very actuarial. But I guess what you can take from this is where the valuation discount rate uses more aggressive assumptions than implied by the benchmark rate. You have a PFAD, and that PFAD is going to be bigger for longer duration plans. So if we liken duration in this context to the maturity of the plan, the PFAD is going to be increased for longer duration or less mature plans. So at this point, Jill gave a couple of examples. I wanted to focus on the impact on the PFADs of changing the fixed income allocation a little bit. And so in order to do this, we've taken a look at the PFADs determined for 2 different sample plans, one open and one closed, under a number of different asset mixes. So if we walk through this table at the top there, the first row presents kind of a traditional 40% fixed income allocation. The second is a slightly less risky asset mix with 50% allocated to fixed income. The third is a slightly more risky mix with 30% allocated to fixed income. And the fourth takes that traditional asset mix and adds a 10% allocation to that bucket that I earlier classified as alternatives. The third column there shows the PFAD that's determined for that sample open plan with a duration of 12. And the fifth column is the sample closed plan with a slightly shorter duration of 10. So again, as Jill pointed out, what we see here is first that the PFADs are higher for closed plans. And second, Jill alluded to this too, there's a bit of, I called it there, an asymmetrical cost to increasing equity. And what I mean by that is depending on where you're starting from, it costs more to add equity in sort of PFAD terms than you would say by adding fixed income. So as we saw before, those incremental PFAD increases, they get higher as you get to higher levels of non-fixed income assets. So what this analysis talks to is really the impact on the PFADs alone. But when we talk about investments and asset mix, there's often a broader question, and that's around a risk-reward relationship. And so really, you have to ask ourselves whether the PFAD cost that's implied by moving to riskier asset classes is rewarded in the long term. Also, the PFADs don't really differentiate by the duration of the fixed income. And when we talk about duration in the context of the assets, it's really the sensitivity to interest rate changes. So because the PFADs aren't really differentiated by the type of fixed income that you're holding, we can also ask ourselves, what is the impact of maybe extending the duration of the bonds that you're holding? So say looking at long bonds, for instance, without necessarily changing the fixed income allocation. Kind of a busy slide, but We mentioned risk and reward on the prior slide, and so this illustrates a sample investment strategies that plan sponsors can look at to manage risk. And specifically in this context, we talk about asset liability mismatch risk, which is really the risk that assets and liabilities move differently to changes in interest rates. So in this slide, they've really ordered some of these different strategies by the potential impact on long-term costs. So at the top of the triangle, you can look at moving from the traditional sort of 60-40 asset mix. A plan sponsor can consider increasing the bond portfolio's duration or interest rate sensitivity closer to that of the liabilities, or next, increasing the actual allocations to bonds. From there, you can look at LDI or full kind of duration match strategies, all the way to settlement or transfer of risk to an insurer, and finally, sort of full plan termination, just get rid of the problem in the long term. So over the next few slides, we look at this risk-reward decision for a sample plan. That's the case study we'll walk through. And that broad risk decision is mainly determined by the fixed income allocation, so we'll start there for this sample plan. Just a bit of context of what this plan looks like. It's a closed plan with the asset mix shown, so about 35% allocated to universe bonds, 45% equities, and a 20% allocation to real assets. The PFAD is 12, so they have a funding target of 112%. I said this is a closed plan. Currently, there's about 23% of liabilities to inactive members, but that percentage is expected to increase over the next 10 years to just over 50%. Okay, so that's the plan that we're looking at. So for actuaries, we couldn't resist here. So for this plan, we looked at stochastic projections of the funded position over the next 10 years, the going concern on the left and the solvency on the right. When I talk about stochastic valuations, it just means that we're able to look at thousands of scenarios for the way the plan can unfold over time, and that gives us the ability to look at a range of expected outcomes. So these charts show that range of expected outcomes in quartiles, but for this discussion, we'll focus just on the middle point of each bar and the bottom point of each bar, which represents the downside scenarios or risk. So if I start on the left side of this chart, of the going concern funded chart, the plan is starting out very well funded, so just over 150% funded on a going concern basis. If we look forward, they're also expected to remain so over the next 10 years, with the expected future funded ratio sitting just below 150% out 5 years and 10 years. So that's the middle points of each of those big bars. However, in downside or risk scenarios, the bottom of those bars, the ratios may fall to about 115% in 5 years and to about 106% in 10 years. So where we look at that funding target as 100% plus the PFAD, we have a line there drawn at 112%. There's a chance that in a 10-year period, the plan could fall below that target. On the solvency side, where 85% is that target, we're calling in this example, the plan begins at about 95% funded, and that ratio is expected to improve to about 105% in 5 years and 117% in 10. But in downside or risk scenarios, we can see that perhaps interest rates can decline or investment returns are poor. That ratio could fall below the 85% target by year 5 or year 10. So this plan sponsor from here starts to look at how does the investment decision change or impact our future expected outcomes. So as I mentioned before, the key risk decision is based on the split between equities and fixed income. So on each of these charts, there are 10 dots on each side. Each of those dots represents the sort of expected and downside funded ratios in 10 years across a broad range of equity allocations from 0% to 100%. Where you expect to be is on the vertical axis, and the worst or the downside scenarios or the risk scenarios are on the horizontal. So without getting into a lot of detail, the dot really to the furthest right in each chart has the highest downside funded ratio and so the lowest amount of risk. So where you want to be on this chart is kind of up and to the right. So if we focus on the left side, the going concern funded ratio, it turns out that the lowest risk portfolio happens at an 80% allocation to equity, so higher than you might typically think about. When you move to the solvency valuation, though, you see that that happens with very little to no equity. So if you think about that 85% funded target, in a downside scenario, it's telling you that you might want to hold sort of 20% or lower allocations to equity. Okay, so that's quite the difference. The going concern valuation is telling you 80%, and the solvency valuation is telling you 20% or lower. So, you know, what's the sponsor to do? Look at the contributions. So we also considered the average contributions over that 10-year period. And so for this plan sponsor, really what we ask ourselves is what does it cost over time? So the first row shows the expected average contributions as a percentage of pay across that broad range of equity allocations. And the second shows the sort of highest possible levels of contributions over those asset allocations. We have a red box circled there. So what you can see is somewhere in the range of 50 to 60% equities, that contribution risk is minimized. So you'll see the lowest numbers there, so 32, 33% for contributions as a percentage of pay. So that's where, in a 10-year period or over the longer term, this plan sponsor would decide to be sort of between 50 and 60% equity. So the broad conclusions that we can take from this are, while under the new rules, going concern results might favor higher equity risk, you still have that solvency valuation that's sort of moderating that decision and favoring lower allocations to equity. So even at this 85% solvency target, the solvency position is still relevant to the investment decision. I just wanted to touch on one last concept. So we talked about increasing or changing the bond allocation in the prior slides. The other point is really just touching on another approach to reduce risk in pension plans, and that's by extending portfolio duration. So for this plan that we've been talking about, as I said, that might mean going from universe bonds to long bonds, or even considering overlay strategies that extend duration even further. And one last slide. The focus here is really on the expected contributions under three different portfolios, one with just typical universe bonds, one with longer duration bonds, and one with very long sort of overlay strategies. And I think I noted before that the PFADs really are neutral with respect to the composition of the fixed income portfolio. So if we focus on that second column, which says that all trials, so for this portfolio, for universe bonds, I'd say that the expected average contributions was 10% of pay in the universe bond scenario. For long bonds, also 10% of pay. If you move to a very long duration strategy, cost goes up a little bit to about 11% of pay. That's in the middle column when we look at our typical set of projections. If we look at a set of projections, though, where we think that interest rates are going to be low or bond yields are going to remain low, so we look at that last column, you see that average contributions are actually much lower when you have this extended duration strategy. So they go from, if you were in a universe strategy, you'd be paying about 13% of pay on average, and that goes down to about 10%. So while it's expected to cost a little bit more in the long term, a longer duration strategy does pay off when interest rates are low. So again, if I just recap the broad conclusions that we take, I think we can sort of extend from this example, are that under the new rules, again, going concern might favor higher equity risk. Solvency results continue to moderate that. And by favoring lower allocations to equity or even longer duration. So these de-risking opportunities, they continue to be relevant. So for sponsors that are just starting out on a de-risking journey, or for those who have been on that path for some time. So I'd close by saying that the risk decision is unique to each plan sponsor. You should undertake it with careful analysis, and that becomes even more relevant as funding and governance policies will become required under the new regulations.
Thank you very much, Daniela and Jill. Thanks for keeping us on time, which is wonderful. We have a few minutes for questions, if there are any questions in the room. I can't see that far, but I see someone at the very back.
Thank you. Thanks, guys. That was great. Catherine, I know. Just a question around the PFAD and the different asset allocations. Broadly, you talk about fixed income and non-fixed income. You mentioned real assets as being, I think, at 50%, is that right? perhaps the things like real return bonds, do they get classified just in the fixed income bucket, or how does that look at?
That they would be classified as
Sorry, could you just try and summarize or repeat the question for those, the benefit of those who are...
The question was, how do real return bonds fit into the asset classification? And I understand that they would be classified as fixed income assets.
I would just say that we've tried to present you, it's a lot of information in a short period of time with as clear a snapshot as possible. These are among the most complex set of regulations that I've dealt with in my, close to 30 years as a pension lawyer. As I said to Joe and Danielle, I felt like I was trying to do grade 13 math all over again while I was reading these regulations as well. But there's going to be some points in here that aren't entirely clear. For example, when you're setting a PFAD based on whether a plan is closed or open, the rules are not at all clear on how you determine whether a plan is closed or not. And there's a number of different variables, so that could play out. Similarly, on the investment side, while the regs are prescriptive in terms of what's fixed income, what's non-fixed income, as we all know, in the industry, new products come along all the time, and how they get slotted into those categories will be subject to some interpretation. Any others? Okay, then. We'll be around for other less intimidating questions outside of the full group after we're done here, but I'd like to invite our next panel of speakers to take the podium, and thank you all for your time.
Yeah, seriously. All right. All right. I think we're ready for our second panel. Good afternoon, everyone, and welcome to our second and last panel of the afternoon. I'm Janice Steele. I'm a partner in the Pensions and Benefits Group. And on our panel today, we have, to my immediate right, Anna Zalewski, and beside Anna, Doug Rienzo, and beside Doug, John Marin, everyone from Osler's Pensions and Benefits Group. So what we're intending to do on this panel is provide a bit of a deeper dive into some recent issues of interest that might be of interest for plan sponsors. We will discuss a little bit of case law, but most of the discussion will focus on the recent legislative and regulatory activity in Ontario leading up to the upcoming election, which we're all waiting results with bated breath for. By way of background, the Ontario government has been quite busy on the pension reform front over the past few years. This year, of course, we've seen the introduction of Administrative Monetary Policies, or AMPs, as Tony mentioned, as of the beginning of January. Also, our budget in March of this year announced several initiatives on the pension front, including continued work on the new DB funding rules and increases to PBGF, which was covered extensively by our last panel, a consultation on the new funding framework for target benefit MEPs, consultations regarding new protections for plan members affected by employer insolvencies, and also continued work on the new pension and financial service regulator, the Financial Services Regulatory Authority, also known as FSRA. As Tony mentioned, we also now have annuity discharge regulations, which have been pending and we've been waiting for a while, so it's great to see those in place. Also, variable benefits for DC plans in the province might soon become a reality. In Ontario, the government recently released a proposal for these regulations for variable benefits from DC plans. So what we have in store for you this afternoon is some more detail regarding where things stand with administrative monetary penalties and the proposed new pension regulator, pension de-risking, and more specifically, the new annuity discharge provisions in Ontario, and also the proposal for variable benefit regulations, including where things stand for variable benefits for DC plans outside of Ontario. We'll also touch on some recent and exciting developments in the world of benefits. So I am now going to turn it over to our panelists, who will start with my partner, Anna Zaleski, and she will start with speaking on the changing pension regulation and administrative monetary penalties. Anna?
Thanks, Jenna. So one of the larger policy initiatives of the current government has been the creation of a new pension and financial services regulator, that, as Jenna mentioned, FSRA. Several pieces of legislation have come into force. Others have received royal assent, await proclamation. Implementation of FSRA is quite far along. We have a board of directors. We have a CEO. There's transition planning in place. There's an announced April 2019 launch date. So that's when takeover, we understand it, flip the switch takeover of fiscal regulatory functions would take place. And now we have an election. So it remains to be seen what will happen. There's quite a bit of a momentum here, but clearly political will is needed for that momentum to continue, since legislation still needs to be proclaimed into force. We need ministerial orders to make everything happen. If the momentum does continue and the transition proceeds, then we can expect to see a new regulator, as I said, in April 2019. Regulator would be self-funded, so expected to have more resources. Being billed as more modern and adaptive remains to be seen. One with an increased focus on consumer and plan beneficiary protection. And in fact, that's part of the specific mandate of FSRA. Now, one of the interesting tools that FSRA would have at its disposal would be rulemaking authority regarding a variety of matters that are now subject to regulation. So, for example, setting time periods for filings and other matters, prescribing information to be provided by plan administrators, prescribing the content of certain documents. I think that is slightly narrower than what the wish list was for FSRA and doesn't have as broad a reach as anticipated, but still would give FSRA, if it comes into place, more flexibility regarding the regulation of the pension sector. So in addition to things like rulemaking power, the other focus with respect to changes in pension regulation has been enforcement, and in particular, as my colleagues have mentioned, administrative monetary penalties, or AMPs. And the Ontario government didn't wait for FSRA to come into place before enacting administrative monetary penalty legislation and regulations. These are in force as of January 1 of this year, and the superintendent does now have power to impose these penalties. And although I'll refer to Ontario today, I'll note that similar regimes are in place in BC and Alberta. And in fact, the Ontario legislation is similar in a number of ways to the legislation in BC and Ontario, although there are some differences. What's important to know about Ontario in particular is that the imposition of penalties is discretionary, so the superintendent is not going to be required to impose any of these penalties as a matter of course, even if there is a breach. The maximum amounts in Ontario are not particularly high. So just to compare that with our current fines under the offenses provisions of the PBA, which could be imposed if there is a provincial court prosecution brought, we have a $100,000 minimum for a first offense, maximum for a first offense, $200,000 maximum for subsequent offenses. With respect to AMPs, the maximum for a corporation or another entity is $25,000. For an individual, it's $10,000. But these penalties are going to be public, so there is a high reputational risk despite the relatively low amounts. And I will just say here that the amounts, the maximum amounts in Alberta and BC are substantially higher. $250,000 for a corporation or other entity and $50,000 for individuals. Importantly, these penalties cannot be paid out of a pension fund,
And this has implications for funds that are administered by boards of trustees in particular, where there's no other obvious source to pay that penalty. And so trustees will have to consider whether they have appropriate insurance in place to cover that risk. And that may not be the standard fiduciary liability policy. There are two types of AMPs, just to give you a bit more background on these. General and summary. The general penalties contemplate more severe breaches of the PBA and allow these AMPs to be levied where there's a breach of the PBA or the PBA regulations. There's a long list of provisions that might attract an AMP if there's a breach, and these include things like noncompliance with plan documents, failure to invest plan assets in accordance with the federal investment rules, failure to invest in accordance with your SIP, failure to give notice to members in various circumstances, including plan wind-up. Breaches of orders made by the superintendent could attract an AMP, as could breaches of an undertaking, for example, undertakings filed by pension, investment, and other corporations. Summary penalties contemplate less severe breaches. Generally, they relate to missed filing deadlines and the like. So, for example, missing a deadline to file plan amendments, missing your SIP filing deadline, et cetera. They take the form of a prescribed daily penalty ranging from $100 to $200 per day up to the maximum. So, for example, if you missed the filing deadline for your SIP by 10 days, the superintendent chooses to impose a penalty, that penalty would be $1,000. Now, how is the superintendent going to impose these penalties? What factors will be considered? We do know something about this, although perhaps not as much as we should know. And in particular, what we know is what's in the regulations. And the regulations tell us that the superintendent is required to consider only the following factors or criteria. First of all, the degree to which the breach was intentional, reckless, or negligent. Second, the harm or potential harm to others resulting from the breach. The extent. Third, to attempt to mitigate any loss or take other remedial action. So how quickly did you react? Did you try to correct errors or breaches that occurred? The other things that will be taken into account are the extent of any economic that was derived or that could reasonably have been expected to be derived, and kind of the history of compliance over the past 5 years. So have there been any other breaches of the PBA, other breaches of pension benefits legislation in other jurisdictions? And these factors really emphasize a number of things for me. Number one, strong governance structure and processes to achieve and monitor compliance. Taking proactive steps to address incidents of noncompliance, not letting things lie, not letting sleeping dogs lie, as it were, which may have been a strategy in some cases. And then addressing systemic or repeat errors. So what is our experience with AMPs to date? None so far. There have been no AMPs imposed in Ontario so far. Fisco, in meetings with stakeholders, has given some comfort that its intention is not to go out looking to impose these penalties, looking for innocent breaches. And the expectation is, and the hope is, that Fisco will develop further guidance on how these penalties will be imposed, the factors to be taken into consideration, procedural matters. So some of the questions out there are, will Fisco's focus really be on persistent or severe breaches? Can we stop worrying about innocent breaches? What type of conduct by individuals will attract an AMP? Since that's an individual, that's a monetary impact on an individual. Will there be a different standard there? Will voluntary disclosure help? Will that be looked upon favorably, or do plan administrators need to worry about that since they're disclosing potentially a breach? Could there be stacking of penalties? So even though we have a maximum of $25,000, if we have a number of breaches related to one incident, is that going to be treated as one maximum? Could we have a number of different penalties there? And could penalties apply prior to January 1, 2018, when this legislation came into effect? There's a 5-year limitation period, but it's not entirely clear whether the superintendent can reach back to years prior to 2018. So if you're interested, there's actually a very good submission that ACPM prepared on a number of these issues to FISCO, raising the desire to have a policy to address many of these.
Thanks, Anna. It is an interesting time watching the change on the AMP coming into place here, because it is something we haven't seen here, right? Previously, we had the penalty sections under the TBA, which were very rarely used, thankfully, because obviously they're fairly serious and significant. But now we have arguably ones that may be easier for the regulator to impose. We haven't seen any yet, but who knows what's going to happen. So, Anna, I don't know if you have any thoughts on what plan administrators can do to help minimize the risk of AMPs being imposed.
Sure. I mean, I think there's a kind of a systemic basic answer to that, and you know, an individual case answer to that. And systemic basis is really governance. You have clear roles and responsibilities, or things falling between the cracks with your administration of your pension plan. You have good reporting, good monitoring, good documentation. That's at a very high level, and that helps show diligence. It helps show good process, and it helps show that you are doing all the things that you should be doing. On a case-by-case basis, as I said, don't let things lie. Address them. And don't let these problems persist or get into a pattern of persistent problems.
Thank you very much, Anna. So I will now pass it over to Doug, who's going to discuss pension de-risking, and in particular, Ontario's new provisions with regard to annuity discharges. Doug?
Thanks, Jana. So, like Jana said, in this part of the seminar, I wanted to give you a bit more detail about the new annuity bio provisions in the PBA that were mentioned. So, just to put this part of the discussion in context, wanted to talk generally a little bit about de-risking. So over the past several years, as we know, a lot of plan sponsors have been looking for ways to de-risk their pension plans, essentially to address the volatility that can arise under pension plans, and to address the liabilities in their plans that they just feel sometimes they can't accurately predict. So those attempts to take some of the risk out of the pension plan have taken numerous forms. So plan redesigns, for example, amending the accrual formula, or as we've seen fairly commonly, converting the plan from defined benefit to defined contribution. As we heard in the last panel, revised investment strategies can be adopted, including, as Daniela mentioned, trying to more closely match assets and liabilities. Sometimes de-risking can take the form of longevity swaps or longevity insurance. We've seen that a couple times in Canada so far. That's where the counterparty or the insurer assumes the risk that the pension plan members will live longer than you currently expect them to live. Annuity buy-ins are another way to de-risk a plan. So the insurer assumes all the liability to pay pensions, but in an annuity buy-in, that annuity policy remains an asset of the plan. The pension payments can continue to be made by the pension plan administrator. That's really a plan investment. Another form of those is an annuity buyout. That's, again, where a policy is purchased to replace the pension payments, and there the insurer takes on all the responsibility to make those pension payments in the future, and that's what we'll be talking about today. The ultimate de-risking strategy, of course, is to terminate the pension plan and just to do something else, have a group RSP or or something else. So the focus of my presentation are those annuity buyouts. Now those buyouts, they've been permitted under the Ontario PBA for some time. A discharge was not expressly provided under the PBA, however, so it wasn't clear whether by purchasing an annuity to replace a pension in pay, the employer was really off the hook. So that raised the issue of so-called boomerang risk, where a claim could be made against the employer if for some reason the annuity provider stopped making the pension payments. There was a case in the late 90s, 1998, the McLaughlin and Ultramar case, and that involved the purchase of annuities from Confederation Life. And as we know, Confederation Life later became insolvent. So in that case, the court held that the employer was not in fact off the hook and that it owed compensation to the plan member after Confed stopped paying his pension. Now, in that case, it was interesting. The court did suggest that a discharge could possibly be written into the plan text. If the plan text was drafted to say that that annuities can be purchased and that the employer would be discharged upon the purchase of that annuity. But that was just sort of an aside in the case. The court was really saying, well, that wasn't in this pension plan text. I don't think there's any discharge, so you employer should pay this pension because Confederation Life is not doing it, and that was your obligation. So as I think Tony mentioned at the beginning, plan sponsors in Ontario have been asking for some clarity on this for some time and have been asking for the legislation to be amended to include an express discharge where an annuity is purchased. So effective on July 1 of this year, a new section of the PBA will come into force, Section 43.1. And that sets out a process, or sets the groundwork for a process that the pension plan administrator can follow in purchasing the annuities if it wants to obtain a discharge. The new provision also permits administrators to obtain a discharge in respect of annuities that it purchased in the past under the existing PBA provision, Section 43, if a similar process is followed now in order to get the discharge. And all the rules for what the administrator has to do in order to obtain a discharge when it's purchasing the annuity is set out in a new regulation under the PBA. So what does the administrator have to do if it wants to get a discharge when it's buying annuities? So most importantly, in order to obtain the discharge, the former members and the retirees for whom the annuity was purchased have to be notified of the purchase. If a retiree has his or her pension being divided following a previous marriage breakdown, then the spouse who's getting a portion of the pension payments also has to be notified of the annuity purchase. In that notice, the former members and the retirees have to receive certain prescribed information about the annuity policy, and they have to be told that if the administrator is discharged, then they will no longer be considered a former member or a retiree under the plan for any purpose, except in certain circumstances where the pension plan is wound up in the future and has a surplus. So this is an interesting sort of twist to this discharge provision. So the regulation, what it says is, if the member is entitled to surplus under the pension plan on the date of the annuity purchase, then the notice has to have a statement that in the event the pension plan is wound up in the future and the plan has a surplus at that time, then the member would be entitled to surplus. The regulation goes on to say, if it's not clear whether the member is entitled to surplus under the pension plan on the date the annuity is purchased, then the notice has to say that in the event the plan is wound up in the future and the plan has a surplus, you, member, may be entitled to some of that surplus. Interestingly, I don't know why this is the case, the regulation doesn't contemplate a situation where the plan clearly provides that the employer is entitled to surplus, which is a bit odd. I mean, you could have a fairly new pension plan where from the beginning they said the employer is entitled to surplus. But that's not contemplated, so I'm not sure what the administrator would put in the notice in that case. Maybe that's meant to be the unclear situation. Also, a little bit unclear, we'll have to see how this pans out in the future, but it's not exactly clear what's meant under the regulation when it says that the member is entitled to surplus on the date that the annuity is purchased. Does that mean that the plan text as it's drafted on that date provides for member entitlement to surplus, or is that some sort of reference to historical provisions of the plan, the things we used to talk about under Transamerica and all those cases where you go back to the beginning of time and figure out, how that trust evolved. So that's a bit of an open question at this time. But for now, I mean, the notice, you have to figure out what you're going to put in the notice. I expect that typically the administrator will put, it's not clear, and that way it sort of punts it to that future date where the plan winds up and, and there's a surplus. So the stars really have to align for that to happen anyway. The regulation also sets out requirements for the content of the annuity policy itself, what has to be in that policy in order for the discharge to apply, including a requirement that the insurer provides each person with a certificate of insurance. There are other things there about joint and survivor pension requirements, pre-retirement, death benefits, that sort of thing. But there's prescribed list of things. Your annuity policy has to have these things in it if you're going to want to get the discharge. The regulation also contains requirements related to the plan's funded status. So when you're purchasing the annuity, if the plan's solvency ratio was 1 or more under the last valuation that was filed with FSCO, then it must be 1 or more after the purchase. If the plan's solvency ratio was less than 1, according to the last valuation that was filed with FSCO, then after you buy the annuities, the ratio must be the greater of 85% and that ratio under the last valuation. So it has to be at least 85%. If necessary, if those thresholds aren't met, then top-up funding has to be made into the plan, and that has to happen within 90 days of the purchase. Again, this has to happen in order to get the discharge. And then in order to get that discharge, a certificate has to be filed with the regulator saying that everything was done according to the regulations. Interestingly, that certificate must be prepared by the actuary, not by the administrator, saying that the process was followed and that all the requirements were met. And then once that is done, then the discharge will be effective. So what the regulation says is, and what the statute says, is that if the administrator is discharged, so the process is filed, the proper notices were given, the proper funding was made, the contract said the things it had to say, then the former members and the retired members for whom the annuity was purchased are no longer members or retired members under the PBA for any purpose, except with respect to possible rights to surplus. So it ties back into that part of the provision. The PBA goes on to say that if the plan is wound up in the future and there's a surplus, then the annuitants have the same rights as any other member of the plan in respect of that surplus. But again, only if they would have been entitled to a payment of surplus under the plan had the plan been wound up back when you made the annuity purchase. If they had those rights, then they have the same rights as anybody else in the future when the plan is wound up and there's surplus. So again, it remains to be seen the exact meaning of those provisions. In my view, most uncertainty around what it actually means for those members to have been entitled to surplus on the date of the annuity purchase. It's interesting because this part of the discharge provisions is a little bit of a surprise. It, in my view, not only contradicts sort of the general principle here. I mean, you buy an annuity in order to have a clean break with the plan members. You want to get these liabilities off your books. You don't want to have to send these people notices anymore. You're paying the insurance company a lot of money in order to start administering the pensions. And this sort of creates a tie between the administrator and the annuitants for perhaps a decade or more, 2 decades, who knows, if there's ever a plan wind-up in the future. It also contradicts an old case, the Farrell case from the mid-90s. That was a Pension Commission of Ontario case that clearly said that if people are annuitized and they're no longer plan members, and in that case they didn't have to be part of the consent group for a surplus distribution. And that was the policy of the regulator for a long time. Unless you annuitize them right on the eve of the plan wind-up and tried to keep them out of a surplus distribution, there the regulator said, well, maybe you should sweep them in because you just annuitized them, last month. But if they were annuitized years ago, the policy of the regulator was they're gone from the plan, you don't have to include them in the wind-up, include them in the surplus distribution. This provision kind of brings all that back. It seems a bit retrograde, but there it is. I mentioned at the outset, the new provision, it contains a process where if there was an annuity purchase in the past, then the administrator can go back and try to fit that into the new provisions in order to get a clear discharge for that past annuity purchase. That could include the requirement to make a top-up payment. The legislation contemplates a scenario where you may have to go back to that insurer and give it more money, essentially, to have the insurer maybe amend the annuity policy to make sure that it complies with the new rules under the PBA. If you have to make some sort of top-up payment to the insurer, then the funding rules, they apply. You may have to make a top-up payment depending on the funding ratio of the plan. So that's just something to keep in mind if you're trying to get a discharge for a prior annuity purchase. Other parts of the process apply, including the notice to the members about the discharge. Sometimes when people are talking about buying annuities, the question arises, well, what happens to the treatment of the liabilities for valuation purposes and for accounting purposes? So up to now, our understanding has been that even without a formal discharge, if an annuity was purchased to replace pensions in pay, then the accounting practice was essentially to treat the liabilities as settled, as off the books. Now, in Ontario, now that there's a formal discharge process available, one question that arises is, will the accountants now say, well, we will treat these as settled if you go out and get the discharge? If you do, you can still purchase annuities and not apply for the discharge because you can still do it under the PBA. Will the accountants start treating those two things differently? I'm not sure they will. I'm just asking the question. In terms of the plan's valuation, before this new PBA provision, the expectation at FSCO was that the liabilities would remain on the valuation with the annuity policy as an offsetting asset. So the asset and liability would still be there. Not sure that was always followed in practice, but that was the expectation. Presumably now, if this discharge is obtained, then the liabilities won't have to be reflected on the valuation at all, because the PBA is very clear. It says once the discharge is obtained, these people are not retirees, they're not former members of the plan for PBA purposes. Again, except for surplus, that little footnote. Just a quick mention about other jurisdictions, because a lot of pension plans have members across the country, retirees who earn the benefits across the country, not just in Ontario. Not all jurisdictions have addressed this boomerang risk. So far, only BC and Quebec, and now Ontario have done so. So administrators could be in a position where they're buying annuities for retirees across the country. The discharge will apply, may apply in a patchwork fashion when it does that. Other jurisdictions are in various stages of considering addressing this issue, including the federal jurisdiction. So just a final note, the PBA provision, the discharge provision, leaves a couple of open questions. First of all, the provision addresses the purchase of annuities for former members and for retired members, as those are defined under the Pension Benefits Act. So it doesn't appear that the discharge is available when an annuity is purchased for benefits accrued to date for actives, for example. It's fairly uncommon, but the legislation doesn't address that. Of perhaps greater concern, it's not obvious in the legislation because it's not mentioned, that if you're purchasing annuities, then you would probably also be purchasing annuities for spouses in receipt of a survivor pension. They're not mentioned in the provision. I think that's probably just a drafting oversight. It doesn't make sense that you wouldn't include a surviving spouse who's receiving a lifetime pension, but they're not mentioned there. Another open question, this one's maybe a bit more technical, but I think it's a fair question, is whether the employer is discharged, because the PBA is drafted to say that if all these steps are taken, the administrator is purchasing these annuities, and the administrator will be discharged. So does that mean that the employer is off the hook? Because if you go back to the McLaughlin and Ultramar case, the court clearly said this employer had a contractual obligation to pay this member his pension. Confederation Life stopped paying it, so you, employer, you have to pay it. The administrator isn't the one employing these people and promising them a pension, it's the employer. It becomes most evident if you have the situation of a pension plan where the employer and the administrator are two different entities. So the administrator could be a board of trustees, and they go off and they purchase this pension. Have they gotten a discharge for the employer? Maybe they have, because the PBA says these people are no longer considered members, former members or retired members for PBA purposes. So presumably the employer could say, well, the statute doesn't cover them anymore. The discharge must apply to us, the employer. But it probably would have been nice to see in the PBA that the employer and the administrator are discharged upon buying the pension, but that's not in the legislation either. So just a couple open questions there, but I'll end it there.
Okay. Thank you very much, Doug. Just a really, really quick question. I know you mentioned that if an administrator bought annuities in the past, it can take advantage of these new rules if they go through the whole process and get the discharge, et cetera. But what if once the rules are in place, so after July 1, 2018, an administrator subsequently purchases the annuities and then doesn't go through the discharge process and then later changes its mind and says, hey, I want the discharge. Can they get it?
Right. It looks like they can, but I think the trick would be that when they're buying the annuity now, they would have had to comply with a lot of the rules. So you can give the notice later. There's nothing in the regulation that says the notice has to be sent within a certain time. So, a couple years from now, they could say, well, we purchased the annuity at the end of 2018. Now we want to go for the discharge. Here's a notice. We're applying for the discharge, just so you know, you're not going to be a member of the plan anymore, except for surplus, et cetera. But they would have had to comply with other things, including the funding. So it's clear under the legislation that any funding top-up has to be made within 90 days of the purchase. So they could get tripped up there because the transitional provisions that let you go back and fix a previous annuity only applies to annuities purchased before July of this year. So the answer is yes, but only if you had done a lot of things right at the time you buy the annuity.
Right. So you should have it in mind that you might want to do it at some point at the time you purchase it.
Absolutely. Yes.
Okay, thanks very much, Doug. Now, our last speaker of the day is John Marin, who's going to speak on variable benefits for DC plans and also some interesting benefits cases. So I'll pass it over to John now.
Thanks, Jenna. So it's clear that the past years brought about some very significant changes for DB plans, both in Ontario and throughout Canada. But what about defined contribution plans? Well, the key driver for change in 2018 for DC plans, and in my view in the foreseeable future, is going to be increased focus by both governments and the regulators on the decumulation or payout phase of the plan retirement cycle. So DC plans and the legislative rules that govern them have traditionally focused almost exclusively on the accumulation phase. And the end result is that most DC plans require members to transfer their DC balance out of the plan at retirement, either through the purchase of annuities or more commonly through the transfer of the DC account balance to a prescribed retirement savings arrangement, such as a life income fund or a registered retirement income fund. The problem is that these options are generally offered on a retail or close to retail basis with high associated fees. Now, there's arguments out there that the lack of decumulation options available to plan sponsors has contributed to the issue of there being less predictable retirement income for DC plan beneficiaries. In response to these concerns, governments across Canada have taken steps to permit the payment of variable DC pensions in order to provide sponsors with another tool. Now, how does this work? So variable benefit provisions permit a plan sponsor to offer life income fund-like benefits from the plan directly to its DC members through the establishment of variable benefit accounts. Now, the benefits are considered to be variable because retired DC members are able to determine how much income is withdrawn annually. That being said, it'll be subject to minimum and maximum withdrawal rules, much like is in place for a life income fund. What's the upside to plan members? Well, members that receive a variable benefit would continue to benefit from investment experts retained by the plan administrator or in-house investment experts, as well as, in all likelihood, lower fees associated with economies of scale. So where do variable benefit rules stand in Canada? Well, the federal income tax was amended years ago, back in 2005, to permit the payment of variable DC pensions. So all good from a tax perspective. You can see from the slide that a number of jurisdictions have already amended their pension standards legislation in order to permit the payment of variable DC benefits. The most recent being Quebec, that brought new rules into force January 1 of this year. However, certain other jurisdictions, notably Ontario, New Brunswick, and Newfoundland, don't yet permit the payment of variable benefits. There has, however, been some progress on this front in Ontario. The legislation, the Pension Benefits Act, has already been amended to introduce variable benefit provisions, although these provisions won't be proclaimed into force until there are accompanying regulations that really flesh out the details as to how these variable benefits will work. In March of this year, Ministry of Finance released a description of proposed regulations as opposed to regulations themselves that would ultimately permit the payment of variable DC pensions. However, since no regulations were actually filed before the dissolution of the legislature, the incoming government is going to have to reconsider this issue and is obviously under no obligation to move forward with the initiative. That being said, given the increased focus on decumulation and the fact that variable benefits are permitted in a number of other jurisdictions, the hope is that Ontario won't lose momentum with this particular reform once the new government's in place. So I think the key question then becomes, will plan sponsors embrace variable benefits? Where the option to provide these benefits is available in other jurisdictions, it's voluntary and most plans haven't elected to do so. I think there's a few factors that contribute to this. So first, for multi-jurisdictional plans, sponsors may be reluctant to make the benefit available where it's not made available in all jurisdictions in which it has members. In addition, there are certain variations to the rules across jurisdictions which create administrative challenges. And in this regard, the lack of harmonization of the rules can create a disincentive. Perhaps most importantly, many employers would question why they would assume ongoing legal risk for their DC retirees by offering variable benefits when there's no statutory obligation to do so. It is a valid concern since an employer that offers variable benefits will have a number of legal obligations in respect of its DC retirees. These could include ongoing fiduciary obligations, obligations as it relates to ongoing member communications, which has been a source of litigation risk. There's also certain risks around errors relating to the calculation and payment of benefits. As I mentioned, members have the discretion to choose how much they withdraw into income in a year, but it is subject to minimum and maximum amounts that the plan administrator will have to calculate and enforce. There are also questions about investment platforms and any modifications that may be necessary to accommodate providing investment options to retirees, and even how those investment options may have to be monitored differently. Just to be clear, this isn't intended to paint a negative picture on variable benefits. Some plan sponsors have the ability and willingness to manage these risks with the potential upside of offering a more attractive DC plan. I would also say that there also is a growing school of thought in the pension industry that an employer that adopts a proactive decumulation strategy, which could include providing variable benefits, could actually be less susceptible to litigation risks at the end of the day, since these strategies do have the potential to maximize DC plan value. Unfortunately, at this stage, there just isn't enough data or case law to tell whether this is true, but time may tell. So in the last bit of this presentation, we wanted to change directions, move away from the pension world, and provide a brief update on some recent developments that impact employer-sponsored health and welfare benefit programs. And I'll start by going a bit off script, as I'd be remiss to not touch on a very recent decision that's caught headlines in the papers the past week. And the case I'm referring to is Talos versus Grand Erie District School Board. I see some heads nodding, so I'm sure a lot of you are familiar with it. In this case, dealt with whether it would be discriminatory for an employer to terminate benefits coverage for an employee that was over age 65. And just to provide a bit of context, currently the Ontario Human Rights Code, working in conjunction with provisions of the Ontario Employment Standards Act, expressly permit an employer to differentiate between workers under the age of 65 and workers over the age of 65 with respect to workplace group benefits coverage. And it's for this reason that it's not uncommon that you see benefit plans designed to provide for certain or all benefits to cease at age 65 or a later date. Now, this case involved Mr. Talos, who is a teacher that continued to work beyond age 65, and consistent with the terms of his plan, his extended health, dental, and life insurance benefits were cut off when he hit age 65. Mr. Talos filed an application with the Human Rights Tribunal of Ontario, alleging that this treatment was discriminatory and a violation of his rights under the Human Rights Code. In its recent interim decision, the Ontario Human Rights Tribunal concluded that Mr. Talos does have a right under the Canadian Charter of Rights and Freedoms to protection against age-based discrimination, and that this right was infringed upon by the statutory provisions in the Ontario Human Rights Code, as well as the Employment Standards Act, that permitted the employer to cease coverage at age 65. The tribunal also concluded that this infringement couldn't be justified as a reasonable limit on his charter rights. So given these conclusions, the tribunal said that these statutory rules couldn't be used as a defense by the school board to Mr. Talos' claim that he'd been discriminated against. So what does this decision mean for employers? Well, as a starting point, my view is that it's premature for employers to go out and amend their benefit plans to remove provisions that provide for cessation of coverage at age 65 or a later date. There is a growing trend in the case law for cases relating to age-based discrimination, and this is the first decision that I'm aware of that's ever come to a conclusion that complying with the Ontario Human Rights Code and the Employment Standards Act would be discriminatory. Given the magnitude of the issue, it seems quite possible that the decision is either going to be appealed or could become subject to a judicial review, as it gives rise to important questions of law. And, I guess at this stage, I'd say that this is just a very important development for plan sponsors to keep an eye on. And so the next topic I'll touch on briefly is cannabis and benefit plan design considerations. I don't have time to go into much detail here, but we wanted to just leave you with a few observations. So first, legalization of cannabis for recreational use. The legislation isn't enforced yet, but it's anticipated that this will be law in fall of 2018. And it won't, strictly speaking, impact benefit plan coverage, since group benefit plans aren't going to be covering the use of this drug for non-medical purposes to the extent it's covered at all. That being said, changing views about cannabis generally has resulted in certain changes to the group benefit landscape with important repercussions. One of those is that certain insurers are now, for the first time, willing to offer medical cannabis coverage as an optional coverage under plan sponsors' group benefit arrangements. Historically, this was only done on a case-by-case basis. And employers, given increasing prevalence of the drug, are likely going to be under increased pressures to do so, potentially through legal challenges. And on the legal front, one thing I'd draw to your attention is that there was recently a case in Nova Scotia where a benefit plan's failure to provide coverage for medical marijuana was alleged by an employee to be discriminatory on the basis of disability. The Nova Scotia Court of Appeal thankfully concluded that denying access to medical cannabis would not be discriminatory and would not be a violation of human rights legislation. And I think importantly, the court focused on the fact that this could be Pandora's box, right? If you say it's discriminatory to deny coverage to marijuana, you could be opening the door to claims that denial of coverage for any particular pharmaceutical or other drug would be discriminatory. So this is a positive decision that reinforces the discretion of a plan sponsor to set appropriate limits on plan coverage, although it's likely fair to say that this probably isn't the last we've heard on the marijuana issue. And a few very quick updates. OHIP Plus, so effective January 1 of this year, free prescription medications were made available to children and youth under age 25 who are OHIP insured. For group benefit plans, this will likely result in a reduction or has resulted in a reduction in dependent drug claims, potential to result in slightly lower costs for self-insured plans, but all grand scheme of things likely not to be a material source of cost savings in group benefit plans. What does have the potential to be much more material is proposed amendments to expand OHIP Plus to provide free prescription drugs to everyone over age 65. And this was one of the aspects of the Liberals' 2018 budget campaign and has obvious repercussions for employers that have retiree benefit programs. Obviously, we'll have to see what happens with this proposed initiative following the upcoming election. And last, I'm not going to go into any detail on this, but the final development I wanted to briefly touch on was the elimination of employee or health and welfare trusts. So in the 2018 federal budget, it was announced that all existing health and welfare trusts are required to either convert to an employee life and health trust or to wind up by the end of 2020. This change will only impact organizations that currently provide benefits through a health and welfare trust. And for those organizations, you'll have to consider the pros and cons of either converting to an employee life and health trust or simply collapsing the trust and providing benefits under an alternative structure.
Great. Thanks very much, John. I'm cognizant of the time here. Thanks very much to our panelists. I'm going to invite Tony Deaver back up to the panel to give us our closing remarks and invite everyone for cocktails and hors d'oeuvres after. We'll all be sticking around, so if people have questions, you can ask at cocktails after. Tony.
Well, sure. In fact, I think we might have time for one question.
Go ahead.
So if there is one question on any of the last topics, I'm going to put you on the spot there. The old man over there.
It's not a question, it's just a heads up. And we discussed this at the tribunal process unit, and Jill will be aware that there's a bit of a glitch. Pension acts like AMPs under the Insurance Act and other pieces of legislation have a 15-day trigger where you can request a hearing. Unfortunately, under the rest of the Pension Benefits Act, or any other matter that the superintendent is proposing to do under Illinois, it's a 30-day trigger. So, and the superintendent can combine AMP with other actions. So, just be aware if you get annoyed and involve an AMP and something else, you've got this bifurcated time in which to until it was.
Thank you, Ian.
Yeah. I think that in summary, there's a glitch in the legislation. And if you get an AMP, you got to, if you want to appeal it, you've got 15 days, not 30, until the glitch is fixed. And with that question, yeah, why is that? So with that, I think that's all we have time for, at least in this more formal setting. I'd like to thank everyone. I'd like to thank the speakers in particular, both in this panel and the first panel. I'd like to thank everyone who attended and were listening. I'd like to thank the people who were participating by the webinar. And once again, since we believe in continuous improvement, we would appreciate it if you did provide feedback either via the online survey or for those that are here in person via the feedback cards. We all look forward to your participation in future seminars, and I invite you to join us outside the room in the North 6 and 7 for cocktails and hors d'oeuvres. So thank you very much, and we'll see you again soon.